Hello and welcome to the webinar on family-friendly rights. Where are we now and what does the future hold? I'm Frances Barker and I'm presenting with Lisa Kelly. We're going to be presenting on maternity leave, paternity leave, parental leave, flexible working and the future of family-friendly rights. There's obviously been lots of changes over the last few years and coming up over the next year, and we're going to give a brief summary on what to watch out for. So as I mentioned, it's the current position on maternity, paternity leave, adoption leave and parental leave, and then the developments we've just seen recently to flexible working and unpaid parental leave. Some of you may have heard in the press and seen on television the proposals to share maternity leave from 2015 onwards. We're going to be covering this as I'm sure it's caused a lot of anxiety and confusion amongst the HR profession. So I'm going to hand over to Lisa to cover the maternity leave provisions.
Frances and I aren't going to go into maternity, paternity and adoption in any great detail, but we thought it would be good to go through all the key points so that we can compare where we are now and where the government is considering taking us in terms of shared parental leave. So with regards to maternity leave, the key rights are that employees are entitled to 1 year statutory maternity leave regardless of length of service. So effectively, ladies who are pregnant and want to go on maternity leave can have a year off and they don't need to have any particular service requirements in order to be able to do that. Maternity leave is made up of ordinary maternity leave and additional maternity leave, and during both of those an employee has a statutory right to the benefit of all of the terms and conditions of employment which would have applied had she not been absent. The exception to that are terms and conditions about remuneration. So obviously the employee's pay can be different when the employee is off on maternity leave. Employees are also entitled to statutory maternity pay for up to 39 weeks if the employee has been continuously employed for at least 26 weeks by the end of the qualifying week, and that is the 15th week before the expected week of childbirth. If the employee's normal weekly earnings are not less than the lower earnings limit, if she is still pregnant 11 weeks before the start of the expected week of childbirth, if she gives the employer at least 28 days notice and supplies a certificate, which is usually the MAP-B1 form, confirming her expected week of childbirth, and she obviously has to cease work in order to be able to qualify for statutory maternity. Also, one of the key rights are that ladies on maternity leave will have that there will be health and safety protection while pregnant and breastfeeding, and also time off for antenatal appointments. And there is protection from dismissal, detriment or discrimination by reason of pregnancy or maternity. So if an employee can prove that they were dismissed because they said that they were pregnant, that would be automatically unfair dismissal. Also, there's a right of up to 10 keeping in touch days whilst the lady is off on maternity leave. And employees on maternity leave who are potentially redundant are entitled to be offered any suitable available vacancy with the employer or an associated employer in priority to other potentially redundant employees. So that's one of the few examples that we have of positive discrimination. So moving on to paternity leave, the key rights there are that since the 6th of April 2003, eligible employees have been entitled to take either 1 whole week or 2 consecutive weeks ordinary paternity leave, and that must be taken within 56 days of the child's birth or adoption. And the general purpose is to enable the employee to care for the child or to support the child's mother or adopter. Individuals taking paternity leave can also have ordinary statutory paternity pay for up to 2 weeks. To benefit from that, they need to have the same service requirements as there are for statutory maternity pay. During paternity leave, employees are entitled to benefit from their usual contractual terms, except for those relating to remuneration. So again, very similar to the maternity provisions. If the service requirement is met and the employee is a child's father or is married to the partner of the child's mother or adopter, and expects to have main responsibility, except from the mother, to bring up the child, and the child's mother or adopter was also entitled to maternity or adoption leave, maternity pay or adoption pay or maternity allowance, and has returned to work, then the employee will also be entitled to a maximum of up to 26 weeks additional paternity leave. Additional paternity leave has to be taken as one continuous period calculated as multiples of complete weeks. The minimum is 2 weeks and the maximum is 26 weeks. It can be taken at any time between 20 weeks after the date the child was born or placed for adoption, and it must end 12 months after that date. Additional statutory paternity pay is only payable during the mother's statutory maternity pay or adoption pay. So effectively, the woman has to have gone back to work and still have some of her statutory maternity pay or maternity allowance left to trigger the father's additional statutory paternity pay.
Thanks, Lisa. And just out of interest, have you found there's been much uptake on additional paternity leave in practice?
I have to say that we haven't. Since this has been introduced, I've not heard of any employers that have been particularly concerned about this, and certainly I haven't had any queries, which is a bit of a surprise, because when these provisions came into force, a lot of employers were really concerned about it, but since then I haven't really had very many queries. How about you?
No, I'm the same. I got quite a few queries when the legislation first came into force, but in practice no one's asked about any scenarios or sets of circumstances, so I've not come across it either. The other thing I was interested in, Lisa, is does it mean that paternity pay will have to match the enhanced maternity pay if an employer offers women enhanced maternity pay in their contracts or their policies? So they have to do the same now for men that might take additional paternity leave?
I have to say that was one of the main concerns when this originally came into force. But the difference between the enhanced maternity pay and the enhanced paternity pay isn't because of sex, and that was the main concern, that it was, you were going to be treating women more favourably than men, or treating men less favourably. However, as we'll come on to talk about later, actually it's not about whether the person taking paternity leave is a man or a woman. It's about their relationship with the child, and therefore it's not based on sex, because you could actually have a couple that consists, a gay couple, for example, that consists of two ladies, and it's actually the other person who's not going to be the main carer for the child that would be taking the paternity leave. So in that case, for example, the difference isn't because of their sex, it's because of the role that they're going to have involved in the child's upbringing. However, I have to say a little bit of caution in respect to that, because we haven't actually had any case law that's tested this point, but certainly in principle, my view is that it's not related to sex, it's related to the role that the individual will have with the child.
Just moving on now to adoption leave. Adoption leave, as I'm sure you're well aware, is very similar to the arrangements for maternity leave. It's got the same ordinary adoption leave period and additional adoption leave period. And also it works in the same way with additional parental leave, in the same way that the male or the other partner can take the second half of it. In terms of adoption leave, though, it's only one of the couple that can take the ordinary adoption leave, and the other may take paternity leave or additional paternity leave or parental leave. You can't have both members of the adopting couple taking ordinary adoption leave. It's the same principle as applies with maternity leave. You couldn't have both partners taking maternity leave either. One point to note for adoption leave is that obviously the evidence that an employee must show in order to be able to take adoption leave is going to be slightly different because they aren't the biological parents. So really this is all about showing the matching certificate, which would normally be completed by the adoption agency, and it would include the name and the address of the agency, the date when the employee was notified that he or she was going to be matched, and the date that the agency expects the child to be placed with the employee. So as an employer, the focus is much more on getting hold of the information from the adoption agency. Just moving on to parental leave rights now. Again, this is something that you'll all be very familiar with. This is a type of statutory unpaid leave, which is in addition to maternity and paternity. On the 8th of March 2013, the total amount of unpaid leave that could be taken per child increased from 13 weeks to 18 weeks. And unlike maternity leave, adoption leave and paternity leave, it can be split into shorter periods. So they might not take the full block period of 18 weeks in one go. They could split it up into bits if they wanted to. And the employee must have 1 year's service in order to be entitled to take parental leave, and they must have responsibility for a child. There isn't a clear definition of what responsibility for a child means, but I can say that it wouldn't normally cover a step parent or a foster parent unless they did have very clear main responsibility and were living in perhaps with the child and the mother or the main carer. But normally it wouldn't cover step parents or foster parents. So just moving on to other considerations, I think Lisa had a few questions around this.
Yes, I think the first question, and perhaps I may have already touched on this when we looked at paternity leave, is whether a woman can actually request paternity leave.
Yeah, I mean, it's an interesting question because the word paternity makes you think of men, obviously. But yes, a woman can apply for paternity leave, for instance, when they're in a civil partnership or even when they're just two women are partners. All that you have to show is that they have the specific relationship with the main carer or the woman who had the baby. So they have to show that they are the spouse, the civil partner, or the partner. There's still the same continuity of service requirements. They must have 26 weeks service on the 14th week before childbirth, or or 26 weeks service by the point that they're notified of an adoption match. So there's still the same service requirements, but yes, it could be a woman that's taking paternity leave.
And what would happen in the case where you've got a couple that's broken up and dad no longer lives with the mother of the child? Would he still potentially qualify for paternity leave?
Yeah, again, an interesting question that does sometimes come up. If he's the child's father, biological or adoptive father, then he gets rights regardless of the relationship with the mother, even if he's broken up and moved out, as long as he still has responsibility for the child's upbringing. If he was not the biological or adoptive partner, then he must be a spouse, civil partner or partner of the woman and expect to have main responsibility other than the mother. And again, main responsibility doesn't have a clear definition, but the point is that the law doesn't intend multiple men to be having paternity leave. So if a woman has broken up with her partner and then has got a new partner who is living in with her and caring for the child, the law doesn't intend both the original partner and her current partner to both have paternity leave in relation to that child. The requirement would be looking at who has main responsibility.
And this has actually come up quite a lot recently. Do grandparents have any of these rights?
Well, no, generally speaking not, because a grandparent isn't a spouse, civil partner or partner for the purpose of paternity leave. But there is a possibility they could be entitled to parental leave if they were able to show that they had responsibility for a child. But I have to say that's highly unusual and a bit like the step parents or the foster parents that I mentioned earlier. It's unlikely that they'd be able to satisfy that requirement. But I suppose one thing that would be interesting, and we're coming on to this in the next couple of slides, is whether on the changes to flexible working requests over the coming months, whether you might have grandparents using the flexible working provisions to apply for their working timetable or schedules to be changed, where they do have responsibility for looking after a grandchild. perhaps, for instance, if they lived in with their daughter who was a single parent, then they might want to have flexible working.
Oh, that's great. Thanks, Frances. So staying on the same topic of flexible working, the Children and Families Act 2014 amends the rules on the right to request flexible working. So from the 30th of June 2014, it removes the requirement for employers to follow the statutory procedure when considering a request and replaces it with a requirement that employers consider requests in a reasonable manner and notify employees of their decision within a reasonable period, which is suggested as being 3 months, unless an extension is agreed. So employees must still be employed and have 26 weeks continuous employment at the date that the request is made, and the employee can't have made another request in the preceding 12 months. So if they satisfy these conditions, then a request can be made from the 30th of June, irrespective of whether the employee has any caring responsibilities. So this is a real departure from the current position, which is that the employee has to have child caring responsibilities. One thing that I think is worth mentioning is that requests may still only be refused on eligibility grounds. So, for example, if the employee doesn't have sufficient service, or if they've made a request within the previous 12 months already, or on the basis of one of the 8 specific grounds that are set out in Section 80G of the Employment Rights Act 1996. And I've set those out on the slide, which are the burden of additional cost, detrimental effect on ability to meet cost demand, inability to reorganise work amongst existing staff, inability to recruit, detrimental impact on quality, detrimental impact on performance, or insufficient work when the employee wants to be at work, or planned structural changes. So I think it will be really important for employers to still recognise that they need to be familiar with those 8 grounds, because they are still going to be the grounds for rejection of flexible working requests. Instead of the current regulatory procedure, there's going to be a statutory code of practice that ACAS has devised, and that's going to be principle-based. That's going to be supplemented with a good practice guide. The code, to be perfectly honest, is very similar to the current regime, and suggests that employees should put their request in writing, date it, and explain the change they're seeking, when they'd like this change to take effect, and to explain the impact that they think it will have on the employer's business and how this might be dealt with. And they should also state whether it is actually a statutory request and whether they've made a previous request. So this is very similar to what we've seen before. Employers must then consider the flexible working request and must arrange or should arrange a meeting with the employee. They should also allow the employee to be accompanied at that meeting. If the employer is going to reject the request, then the code suggests that employers should allow employees the right to appeal against that decision. So that is very similar to what we've seen already. However, hopefully it's not quite as regimented as what we've previously seen, which in the past has led to employers committing technical breaches of the regulations because, for example, they've decided to try and recruit for a job share where an employee has made a request to work, half of their full-time equivalent, and they haven't formally agreed an extension to the procedure in writing, so then that's resulted in a technical breach of the regulation. So hopefully it won't be, it'll be less rigid. However, employers should still be very careful to make sure that they do refer to the 8 statutory grounds for refusal if they are going to reject a request, and they should also be careful not to inadvertently discriminate against employees because of a protected characteristic. So, for example, where an employee is disabled and has made a request, then arguably if they don't grant that request and it's not reasonable, the grounds of refusal aren't reasonable in the circumstances, that could be a failure to make reasonable adjustments. And also the risk of indirect sex discrimination claims will also remain.
Thanks, Lisa. One thing I've been asked by clients is whether I think the change to flexible working requests, and particularly the extension beyond care responsibilities for children, is going to change the way this operates in practice. I'd be interested in what you think.
By reference to the code is very, very similar in terms of its principles to the regulations. So whilst it's not as prescriptive as it used to be, the process, I envisage it being very similar to what we currently have. So from that perspective, I don't see a dramatic change. Where I do see a change potentially is the fact that by removing the requirements to have childcare responsibilities or caring for a disabled child or caring for a disabled adult in certain circumstances, because that requirement has now been removed. You could, as you said previously, you could get grandparents, for example, who look after their grandchildren, making flexible working applications, or indeed anyone can now make a flexible working application. So I think the biggest challenge for employers is going to be balancing the number of requests. The code, the supplementary code, does actually touch on this and does suggest that employers should, rather than trying to sort of take an overview, they should still very much look at each application and assess that on its own merits, rather than just having a blanket policy with, well, we've already got 3 people in the department that have made an application for flexible working, so we're not accepting any more. The code suggests that you shouldn't approach it like that, and you should instead still look at each application on its own merits. And if you do have a situation where you think it will impact detrimentally on the business to accept another flexible working request, the code suggests that what you could potentially do is write to everybody in the department and suggest that, are there any volunteers for individuals who no longer wish to have flexible working requests and would like to revert to their original contract? And you may actually find that some people would like to increase their hours because perhaps when they made the flexible working request, they had kids that were still at school and now their kids have grown up, so they no longer need that flexibility. So the Good Practice Guide, which supplements the code, is a good place to have a look if you do find yourself faced with that type of situation.
And I mean, it might be a finger in the air question, but do you think there'll be a landslide of flexible working requests?
I think it's quite difficult to say at this stage, and to be honest, I think it will vary from sector to sector. So I think it'd be very difficult to give a one-size-fits-all. But I think it's something that employers should definitely be considering, because they may well get an increased amount of flexible working requests. And as I say, I would definitely suggest that employers familiarise themselves with the ACAS statutory code and the supplementary guide, which is very helpful in this area.
So just moving on to the next slide. This is just a brief one in relation to parental leave. As I mentioned already, in the 8th of March 2013, that increased from 13 weeks unpaid leave to 18 weeks unpaid leave per child. The government has announced that from 2015, the unpaid parental leave entitlement will be extended to children up to the age of 18, whereas at the minute it's limited to only up to the child's 5th birthday unless it's a disabled child. So it's going to be open to more people in future. So one of the big areas of uncertainty at the moment in the family-friendly rights is the shared parental leave. Now, by this I don't mean the unpaid parental leave that I was just referring to. This is the concept that maternity leave will be shared between the 2 partners. The idea behind it, obviously, that parents should have greater flexibility to decide who should spend the early months and weeks with the child, and give fathers more opportunity to have time off with their baby. It's still very unclear at the moment how this is going to work. The initial suggestion is that the woman must still take the 2 weeks compulsory leave just around the birth, and that's obviously for health and safety reasons and recovery from the delivery. So that won't change, but then the 50 weeks following that, so the remainder of the maternity leave period, that's ordinary and additional maternity leave, can be shared between the two parents, and they can agree how they want to do it, whether they want to have the woman off for a period of time and then the man off, or indeed, interestingly, whether both parents will be able to take it at the same time. Now, if they take it at the same time, I have to stress that it's 50 weeks in total between them, so you wouldn't be allowed to have the mother take the full 52 weeks and then the father take an additional 50 weeks. It's 50 weeks between them after the 2 weeks compulsory leave, so you could have them both off for the first 25 weeks after the compulsory maternity leave. The government has said that although they're going to publish sort of a draft code and guidance around this, that they're going to be very light touch and not prescriptive on the way this shared maternity leave is going to work. They don't intend to be prescriptive. The idea of this being that it's very much about the parents and the employer agreeing on a pattern that works for both parties. And I have to say, from an employer's advisor's perspective, that's very loose, quite difficult to appreciate how that's going to work, and makes it very difficult to advise on how it should operate. And I wonder whether it might be helpful if they gave some guidance, a bit like they do for flexible working, on when certain patterns can be refused. So, I mean, one of the questions I had is how likely is this going to be used going forward? I'm not convinced that it's going to be as popular as perhaps some people first thought it might be, and the reason for that is additional paternity leave, which Lisa talked about earlier, originally panicked everyone, thinking, well, a man could have the final sort of 6 months off after a baby's been born, and actually the uptake has been pretty low, and I think the same will apply to the shared parental leave or shared maternity leave. I would be surprised if it has a huge uptake. The only caveat I have to that is where the man, the father, or indeed in a homosexual couple, for example, if it's two women, then the other woman has a job where they are entitled to very enhanced maternity pay rights. Then, for instance, if they're in the public sector, they work for the NHS or they're a teacher, it may be in their interest to take it financially and for the woman to go back to work. Although I'm not sure, again, how much emphasis couples will place on the financial aspects as opposed to the woman having time off bonding with their baby. I don't know. But that's the only question I have, is whether people with a father that's in the public sector might want to take this up as being more a greater financial incentive.
And another question that we've been getting, Francis, is which employer will pay for this?
Yeah, it's tricky, but it's going to be the employer that has the employee off taking the maternity pay, or maternity leave, or shared parental leave as it's referred to. So it does mean that in future, fathers' employers could be footing a large proportion of the bill. But ultimately, my view is that this will balance out overall between mothers and fathers, employers, and also I do wonder whether it might help with some of the cynicism around recruiting young women, because in future the cost isn't necessarily going to just be with female employers, but it could be with young men's employers as well. So it might help with recruitment of young women if actually there's no determining factor as to whose employer will have to pay for the maternity or parental pay.
And what about the evidential requirements? Because presumably, you know, if you've got a father, say, that's going to take a significant amount of shared parental leave, will he still be required to bring in a copy of the MAP B1 certificate? How will that work?
Yeah, absolutely, Lisa. I mean, we haven't been told for definite what the evidential requirements will be, but one thing's for sure, the evidential requirements will be really important, because unlike a pregnant woman, where it's obvious that she's pregnant, for a man, like with paternity leave at the moment, it's very difficult for an employer to tell how genuine is the pregnancy or the adoption. And so evidential requirements will be crucial, and yes, they will have to bring in evidence such as the MAPS B1 form, even though it relates to their partner.
And I guess touching on the point about enhanced pay, etc., will employers need to change their maternity, paternity and adoption leave policies? Will they need to be updated?
Yes, ideally they should be, because I think it would be a huge omission to leave out the shared parental leave if you've already got references to paternity and maternity leave. Having said that, of course, it is going to be a statutory framework, and so employers that are very light in their staff handbook on family-friendly rights could fall back on the statutory framework that will be there in the background. But that then makes it very difficult for managers and HR to deal with it. So yes, I would recommend that policies are updated to refer to this.
But presumably you'll be to suggest that they wait for a while until we have a bit more certainty around this.
Yeah, and it's not possible to update policies now, because simply we don't know what's going to happen, how exactly the shared parental leave is going to be set out in legislation. And as I said, the government has said it will give a light touch and not be prescriptive, but there will be some framework that will need to be referred to.
And finally from me, can an employer refuse shared parental leave?
In principle, they can refuse to the pattern that has been suggested by the parents. They can't refuse to allow a parent to have shared parental leave altogether, because that's going to be a statutory right once it's implemented. But what they will be able to do is refuse to the pattern. So, for instance, if the mum says she wants a month off, then the father wants a month off, then the mum wants a month off, and the father wants a month off, that would be very difficult for an employer to manage. Or two sets of employers to manage. And so an employer is going to be able to refuse to the pattern, and the default position will be that it will fall back on the current statutory maternity type arrangements, where it will be in block, and then the additional paternity leave would fall at the end of that. I wonder whether guidance will be given about the grounds for refusing a pattern, a bit like flexible working. I certainly think it would help if there was lots of guidance given around this. Just one final point to note before I finish is, interestingly, the employers of the mother and the father, or the two parents, are not going to be obliged to talk to one another. They will rely solely on correspondence and conversations with their own employees. So that means that they're going to be very dependent on, for instance, father's evidential requirements and demonstrating that what's been agreed with the mother, because the employer won't be able to phone the other employer to check. And that's, I suppose, comes back to things like data protection rights as well, and not being able to inquire about another person's personal sensitive data.
That's great, thanks, Frances.
So that's the end of our session today. I hope it's been helpful. If you would like to ask us any questions, our email addresses are on the next slide. But equally, you can do it through our Muckle forum on LinkedIn, or via our website, which has got various contact details. Please keep an eye on the events that we've got coming up on our website, and importantly, we will have our employment roadshows in the autumn, which will cover all new changes to employment law, and this will include any updates we have at the time about family-friendly rights.
Thanks very much.